Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Yay, says Courtney. Honestly, I said I would regret it when I said I would do a second show today. I already do. I should have left everything set up in the kitchen. It's in my office now. It'll be back in the kitchen tomorrow. Oh, no. No. I already understand how long it took. It was too long. But I'm looking right at you now. Unlike in the kitchen, where I had finagled things, but the cookies, they did turn out delicious. I ate one singular cookie, ladies and gentlemen. I really need some guys in the truck, though. You don't know how frustrating it was. The hat says bread. Bread, baby. Honestly, I'm wearing a hat because my head is disappearing. The black hat's not really working. It's less cool. I don't know what's going on here. And so the yellow hat seemed to do the best. But now my hair is getting all caught up in it. Oh my god. Oh, to be a blonde. Oh, I do love being blonde, though. Anyways. We're going to watch some court that I absolutely already have prepared. 100%. 1,000% even, I would say. It's probably 1,000% that I already prepared that. I look like shit too. Okay, let's start that. Let's click that. Oh, maybe? Is it connected to Wi-Fi? Is that the problem? Judge.
Well, now let's go ahead and swear everyone.
We're going to skip ahead part of this because we're not here for the whole thing. We are here for... What are we here for? What are we here for? Why are we here? Oh, yeah, Mr. Slay. That's who we're here for. Is it? Ugh. We're going to have to start at the top and work our way down. I don't know, Carla. I was a brunette for a long time. Definitely having more fun as a blonde. Oh, God. Creed has Grotto. I have Paisley. I just want to point that out. I love that Creed can't do any of it, so he has Grotto. But, normally you just gotta figure shit out. And that's why my stream is shit. Anyways. Fuck. I guess we're gonna have to watch this whole thing. Oh well. More court for us. Whatever.
Appealing one eviction matter. Okay. Well, now I'd like to go ahead and swear everyone in. So if you're here today and you wish to testify, if you want to tell me what's happening in your case, then I'd like to swear you in as a witness. So please raise your right hands now. You understand that by a period in court offering testimony, you are swearing or affirming to tell the truth, the whole truth, and nothing but the truth under a penalty of perjury. Do you so swear or affirm?
Your Honor.
Thank you. All right. Well, the first
I
case,
swear. I don't know how to do this.
you're
Sorry.
fine. Thank you. All right, our first cause this morning will be 25001300. This is MAA Onion Creek versus Robert Donkey, Christopher Jones, and others. Do you have someone here on behalf of Onion Creek?
Hey, Judge Holmes, it's Haley.
Good morning, Ms. Samuels. Do I have someone here on behalf of Robert Duncan?
Your Honor, this one is plaintiff dismissal.
Oh, you got it, Ms. Samuels. You're non-suiting, court will accept. Any other?
Yeah, they vacated. We're good.
All right, if that should really matter, you're all excused. Thank you.
All right, have a good day.
You as well. We're gonna be with 251333. That's Southwest Leasing Solutions versus Blessing White. Who do I have on behalf of Southwest?
Ashley Bonilla.
Good morning, Ms. Bonilla.
Good morning.
And are you management counsel, agent, owner?
Management.
All right. Do I have someone here on behalf of Blessing White?
Yes, I'm here.
Good morning, Ms. White. Thank you for being here.
Good morning.
All right, Ms. Bonilla, why is this eviction being sought?
This is for non-payment of rent. Notice to vacate was delivered on September the 8th via certified mail. And as of right now, there hasn't been any rent paid. Her rent is in the amount of $1,200. Sorry, I didn't mean to interrupt you there.
Nope, you answered the question, we're on the same page. So the monthly rent is $1,200. Is there any subsidy?
None.
All right, what months are owed?
September and prorated for October.
Was this a CARES property?
No, ma'am.
All right. Good morning, Ms. White.
Good morning.
Thank you for appearing. I understand. My clerk let me know that you've got kind of a short timeline, so we're glad you could make it. Ms. Bonilla says that the case is being sought for a financial reason, so I understand, especially if you're trying to get back to work then. Ms. Bonilla said that.
Yeah, I've been going back and forth from here in Colorado. My mom was diagnosed with breast cancer, so I've been dealing with that. But when I get off work today, I was going to pay the rent.
All right. Well, Ms. White, let me ask you a few questions. And I do.
Yes, ma'am.
I wish your mother very, very good recovery and treatment. Okay.
Thank
Ms.
you.
Bonilla said that under the lease, the monthly rent is $1,200. Is that correct, Ms. White?
Yes, ma'am.
Okay. And is it correct that September and October are unpaid?
Yes.
Okay. Well, with that information, the court, we find in favor of the plaintiff because they've met their burden. Now, you have 5 days to appeal. You can also reach out to the landlord. Occasionally, if parties, if the landlord is made whole with money, sometimes the landlord tells me they no longer want the eviction. But legally, Ms. White, I have to advise you that as of today, the judgment will be for the plaintiff, the Southwest, and the amount is going to be a prorated amount. So under the lease, you owe the entire month of October already. For the judgment, they do a prorated through the actual hearing, so it's going to be a little bit different number, okay? But
Okay.
for the month of October, if I took 1,200 and put it by 31, you're paying about $38.71 a day. Today is the 7th, so that's $270 and rounded up. We'll just put it at 271. All right, so the judgment today would be $1,471 plus cost of court. That's why you can appeal that decision. The appeal bond is $1,200. If you can't afford that, you can't apply for an affidavit of inability. And Ms. White, we got your email address when you checked in. We will email you information about the judgment and the appeal deadline. Again, you have 5
Okay, so the
days.
total that I paid today, I'm sorry, the total I paid today is $1,471.
That's the judgment of the court. But per your lease, the
Okay.
landlord says you owe them $2,400 plus late fees.
Right. Okay.
Okay? So if you want to try to resolve it, call your landlord and see what number they give you. But the court order, what I'm going to say you absolutely owe per the law is today it's $1,471. Okay?
Okay.
All right. This is why if you take no action after 5 more days, that's the soonest the landlord can legally make you move out. Okay? They can't do that beforehand.
11
You have at least
months.
5 more
Thank you,
days.
Shane.
Okay. And I'm sorry, I'm trying to write this stuff down before I go back. The total that's due is 2,000.
Ms. White, the judgment in court today is
I get that part. I'm saying what's the total amount?
call your landlord for that one. I can only know that the lease says 1,200. So per the lease, you probably already owe 2,400 and there may be late fees. For that number, call the landlord because I wouldn't be able to give you that one. All right.
Okay.
All right.
You didn't.
Good luck to you, Ms. White.
11
Good luck to your
months,
mother
Shane?
as well.
Thank you.
All right. Thank you. All parties are excused. Ms. Bonilla, did you have others today? If not, you're all excused for that for the morning.
No, ma'am. That's the only one. Thank you so much.
Well, then we'll be with cause 251304. That's Great Forest Development versus Deha Neal, Cassie Hawkins, and others. On behalf of Great Forest.
Jessica Weiss with Nationwide.
Good morning, Ms. Weiss.
Also, the committee manager.
Nationwide is
Morning,
on
Hatcher.
your
Oh, good
side.
morning, Ms. Hatcher. Thank you as well. Do I have someone here on behalf of Deha Neal?
Yes, I'm here.
Good morning.
Good morning.
Do I have anyone here on behalf of Cassie Hawkins?
Where is the Louvre? Got one. Thank you, Shane. That is so sweet of you. 11-month support and you gifted a membership. I appreciate it, baby. Woo.
No. All right, good
We
morning.
do,
Ms.
Your Honor. There we
Oh,
go.
he's here. Okay.
Is Hawkins here as well?
Yes.
Okay, fantastic. All right then. Ms. Weiss, why is this eviction sought?
For non-payment of rent, Your Honor, the monthly rent is $1,770. They owe back rent for August and September in the full amount of $1,770 for a total of $35.40. I prorated for October at $399 for a total of $39.39. The notice to vacate was hand delivered to Cassie or to Mr. Hawkins on September 5th of 2025.
Oh my gosh, Carla gifting a membership. Getting given to Buzzy Pug. Amazing. Thank you so much. Who's robot voicing? Probably they are. It's just the way it is when I record it fast so that we don't miss it. Unfortunately, I am one lady with 3 computers, so I do my best. Also, you caught me in the middle of sending a little cutesy... What time tomorrow am I going live? During the day? I don't know. Probably 11-ish? Billy! Yay! Do. I am having a great day. Today has been great. A lot better. Thank you so much. And it's getting better and better as we go on. You guys are amazing. I'm having a great night. We're going to have chicken Caesar wraps for dinner. I'm not going to have Caesar dressing on mine, but that's okay. And yeah, I just sent off a cute little pic. Okay, life is good. Thank you, Billy. Thank you, Carla. Woo!
Any subsidy?
No, not that I saw, Your Honor.
All right, was it secured property?
No, not that I was aware, not that I'm aware of.
All right. Good morning, Ms. Neal, Mr. Hawkins. Thank you for joining us. Ms. Weiss works for a company called Nationwide. I see her group a lot. They do quite a few cases on behalf of landlords. You may have never seen her or heard of her, but she's not someone who's going to be down at the office, okay? But Ms. Weiss says that this case is one related to finances. She said that under the lease, the monthly rent is $1,770 or $1,770. Is that correct, Ms. Neal, Mr. Hawkins?
It is correct, yes.
Okay. And then she said that rent wasn't paid or hasn't been paid for August, September, and now October. Is that correct as well?
Well, July and August was initially supposed to be free, but I guess because I'm behind in rent, I now owe that. But so I don't necessarily agree with August because July and August was supposed to be free.
Was that like an incentive when you moved in? They do a concession of some sort?
Yes, for signing a 15-month lease.
Under the lease, does it say if you fail to make payment on time that the concession has to come back? Because that's typically what I see, and that's why. So that may be the answer as to why they're asking for that now.
Yes, and it does say that.
Okay. And how about September? Was September paid?
I did try to pay September. They disabled the portal on August like 20th, and I had it set up with a company where I could like split the rent payments where they, I pay them a portion and they pay the rest. But because the portal was disabled, they weren't able to pay it.
Okay. That's not uncommon. I hear that too. Once one payment is missed, they stop the portal and then it gets a little bit more difficult after that. All right. And same thing for October, not able to make a payment.
Correct.
All right. I will say this, today it's a judgment for the plaintiff, but you certainly can talk to the landlord now and see if some resolution can be reached. They don't have to. I'll be really clear. Legally, the landlord can say, we want your money and we want you to move out.
Okay.
But I have definitely had situations where kind of in this situation, they couldn't accept the money until the case is heard, but you can call them and try to work it out in the next 5 days. If you do nothing, the judgment becomes final on day 6.
Okay.
Okay, and that's also the soonest that they can get rid of possession. So All right, then, today it's gonna be a judgment of salt, it's 39.39. And that number is based on all the month or August, all the month of September, and then a very small portion of October. So she's only asking for the 7 days of the month. Remember that the portal or the balance they give you, if you called your landlord, is quite likely going to be a higher number. It would probably be all of October and may include things like late fees or utility bills if those are also due. Okay?
So for the appeal, what would I have to, if I want to do the appeal, how much would I have to pay? Just be the
Or-
17?
No, because this one is since August. Well, yeah, I put the appeal bond at 1770. And if you can't afford the appeal bond, but you still want to do it, you may qualify for what's called an affidavit of inability. And
Okay,
then here's the thing, and we're gonna send you this information in writing. We send it to everyone in English and Spanish. If you appeal, even if you can appeal for free with the affidavit of inability, in order to stay living in the apartment while the case is being heard before a new court, you have to pay rent of 1770 every time it comes due. So first you have to pay it for the month of October, and then you got to start paying it November 1st, and so on. Otherwise, the landlord gets a writ of possession, you still have to move out anyway. Okay, so those are two different things. So please do look at your options if you want to do appeal. We will send you all that today. So judgment is 39.39 plus cost of court. Either party can appeal. Appeal bond would be 1770.
okay.
All right. Any other, because Ms. Neal, those are great questions. How about Mr. Hawkins? Any questions from you, sir?
No.
All right. Ms. Weiss, anything?
No, Your Honor, thank you.
All right. Good luck to all parties, and all parties are excused.
All right, thank you.
It is 251332.
They will be a huge hit, Erica.
That's Bridgepoint Ventures versus Larry Joe Barta. On behalf of
People
Bridgepoint.
ask for these cookies
Yes,
all
Your
the
Honor.
time.
My name's Hong Lee with Bridgepoint.
Good morning, Mr. Lee.
Morning.
Do I have someone here on behalf of Larry Joe Barta?
I
I see,
suppose,
Mr.
Hector,
Barta, I
if you
see
need
you
to
there.
leave.
You'll need to unmute, sir. If you press star
I'll be here for a
6,
little while. We're
on
gonna
your
hear one of the
phone.
highest rent payments I've ever heard of.
I'll send you a request to unmute you, sir.
There it is.
Good morning, Mr. Barta. Thank you for being with us. All right.
Yes,
Mr.
ma'am. How
Lee,
are you doing?
You know, I wish the air conditioner worked better in here, but I'm not going to complain about it. Or at least not. All right.
Okay.
Mr. Lee, good morning. Tell me why this eviction is sought.
Your Honor, we're here for non-payment of rent and also some lease violations. As far as non-payment of rent, we had served the 3-day notice September 5th. And also prior to that, but I guess the latest was September 5th that we filed on. We served it in person and also regular mail. The tenant is behind $660. And if we add the October rental portion, it's another $132, so a total $792.
Mr. Lee, how much is the monthly rent? Start with that.
Okay, the monthly rent is $13.86 per month. It is assisted rent, government assisted $12.54 per month, and the
Okay,
tenant portion is
yeah, his portion is
$132.
132.
Yes, Your Honor.
Okay. What months are unpaid?
From May 1st through October 6th. So that's 6 months.
No. Is this a CARES property?
It is not.
All right. You said the notice to vacate was, you said it was delivered in person and via mail. Was that hand delivered or was it on the door and mailed?
It was hand delivered September 5th.
Okay. All right. And then you said there's that's the non-payment measures. What about the lease violations?
The tenant has extra occupants living with him, and we've tried to work with him for many months now to not do that, but he's kept them more than the 10 days guest policy and for months. And along with that, there comes unauthorized utility use. There's unsanitary residents. There's always trash and garbage we're trying to manage and ask him to clean up. And there's also, I've got a list here, but there's
That's
more.
fine. All right. Good morning, Mr. Barta. Thank you for joining us.
Yes,
Mr.
ma'am.
Lee is here. He's on behalf of the landlord. And he says there's a
ma'am.
few reasons, but one that's pretty easy to talk about is going to be the rent one. So he says that the amount you owe, sir, is $132. Is that correct, Mr. Barta?
Yes, ma'am.
Okay. Mr. Lee says that rent hasn't been paid for several months now, that it's remained unpaid since May. Is that also correct?
I guess so, ma'am.
All right, well, Mr. Barter, with that information, the landlord would receive an eviction today. I wanted to make sure I give you full information. Do you immediately already have any questions for me?
Ma'am, I'm been trying to just and take care of it. I got 300 for him right now. I do want to pay stuff. I'm trying to get paid.
All right, sir, I understand your desire to pay. The landlord may be willing to work with you after this, but per the contract, it has to be paid on time. So,
Yes, ma'am.
if it remains unpaid since May, I find that would be $132 for 5 months. I get $660 through
Okay.
September.
Like I said, right now, I have 300 for him right now.
And then I get $30 for the amount that's due through today. So, Mr. Lee, Mr. Barta, today the court would calculate back rent at $690. That is what's owed and due to the landlord at this stage. So, Mr. Barta, that would be the judgment, $690. Either party can appeal. The appeal bond would be $264. Mr. Barta, if you're receiving a government subsidy, quite likely you would qualify for the affidavit of inability. However, in order to remain in your apartment, if you appeal, you do have to pay the $132. You pay that directly to the courthouse. We will send you instructions specifically about that. Okay, sir?
Okay. Yes, ma'am.
Any questions for me? Otherwise, all parties are excused.
Okay, thank you, Your Honor.
Good luck to you both. Good luck, Mr. Barta. Thank you, Mr. Lee.
$132. Holy fuck! I would pay
I
that.
understand
I
that.
would pay a year in
Thank you,
advance.
sir. Have a better day. All right, next is 251320. That's Great Forest Development
I'm
versus
trying
Janet
to
Cott and others on behalf of Great
smile a
Forest.
lot.
Got anyone here on behalf of Great Forest Development, cause 25001320? Should you check into that one?
I'm sorry, Your Honor. That one's to be dismissed.
Oh, got it.
Sorry about that. The order's
Dismissed.
off on that.
Dismissed. Big D.
Then it is 251322. LG Terrace Apartments versus Michael Shane Bryan and others on behalf of LG Terrace.
Yes, John Hedrick, Hedrick.
Good morning, Mr. Hedrick. Do we have anyone here on behalf of Michael Shane Bryant? Anyone here for the defendant, Michael Shane Bryant?
No, so we're gonna skip.
Just the last one.
I want to go to the case with Angela. Oh, Judge, that was a cute look. Aww. Hold on. I'm gonna screen grab that for her. Oh, fuck. Okay, good. I thought it got rid of it for a second. It did, but we got it back. First, forward. Now, here we go. This is the case that I wanted to watch today. It gets split up into two. They have to go to a breakout room, but let's get to it.
This can also refer you to other services. Okay, ma'am?
Okay, thank you.
Good luck, ma'am. Good luck. Thank you both. All parties
Thank
for
you.
that matter are excused. Then we're going to be with 251337.
Is that her
That
crying?
is Angela Roberts and Stephen Roberts versus David Benjamin Slade and April Slade.
Hold on. What the fuck was that? Oh my god. What? Did she fall out of a chair in the courtroom? That's a callback, ladies and gentlemen. A callback.
Good luck. Thank you both. All parties for that matter are excused. Then we're going to be with 251337. That is Angela Roberts and Stephen Roberts versus David Benjamin Slade and April Slade. I have someone here on behalf of Angela Roberts and Stephen Roberts.
Yes, Your Honor. Good morning. Daniel is here on behalf of Angela and Stephen Roberts, along with my colleague Justin Cox, and Ms. Roberts is also here virtually as well.
Good morning, Mr. Olds. Do I have anyone here on behalf of the defendant, David Benjamin Slade or April Slade?
I'm here representing pro se my wife's and my interests. I wrote you yesterday evening, Your Honor. He's on Dustin Sweats. Norovirus has run through our family over the past week. We have 3 small children, 3-year-old, 2-year-old, and a 4-month-old. And we believe this is a retaliatory eviction, and we are, I have not had time to retain counsel and gather everything necessary. And so I'm pleading for a 2-week extension.
I wouldn't be able to do that at all. Mr. Slade, these are considered time of the essence cases, and by law, they must be set within a specific amount of time. Let me take a look at the filing. At best, I might could give you like 24 hours. But more likely, you would just have to appeal, and the appeal is what might give you the time that you need to seek counsel. But let's take a look. Mr. Olds, do you know what day the case was filed, just straight away?
It was, I believe it was September 19th. Let me double check that.
Yep, no, you're right, 19th. Let's take a look. All right.
And Your Honor, I would just point out.
Oh, don't. I'm trying to count. 1.
Okay.
This case might be one of the most interesting ones, eviction ones we've ever heard.
All right, Mr. Olds, go ahead.
I was going to say, Your Honor, a week after that was filed, Mr. Slay emailed one of my colleagues here in my law firm the draft lawsuit that he said he was going to file or have filed in Travis County District Court that was reportedly signed by an attorney against my clients, Angela and Stephen Roberts. And so I think, this notion that he wasn't able to find an attorney for this lawsuit rings a little hollow. And he's able to apparently find one to get the lawsuit against my clients in district court.
So, Mr. Olds, what you're saying is that the defendant has sued your clients in district court?
No. He has not sued them, but he was threatening a lawsuit. So he sent a draft lawsuit that was fully drafted against my clients.
Was it
from
counsel?
No. He sent that to my fellows, but it was signed by apparently an attorney.
Okay.
I'm happy to share my screen if wants to see that.
Yeah, Mr. Olds, so you got a letter from a lawyer on behalf of the defendant?
My colleague got an email from Mr. Slade himself with a draft lawsuit.
Involved in that.
I don't know how Mr. Slade found this lawyer. I think he has the same last name.
So that's, again, I'm getting lost. Mr. Olds, you got a letter from the defendant, but the defendant sent you a letter from a lawyer that has the same last name. Is that the story?
No. My colleague in my law firm received an email from David Slade.
Okay.
That email contained an attachment of a draft lawsuit that was styled against my clients. That looked like it was going to be filed in Travis County District Court. And it was purportedly signed by an attorney, I believe with the same last name, so there might be a relation to Mr. Slade. But so my point is that he seemed to be able to find an attorney to do that, but not to represent me.
You received your colleague at your firm received a letter from the defendant, and the defendant sent a letter from a lawyer. Who's a draft lawsuit?
An email, yes, with a draft lawsuit, yes.
All right. Mr. Slade, is that correct? Did you send reported a draft of a possible lawsuit?
My mother-in-law is filing a lawsuit against the plaintiffs for negligence and duty of care. When we moved in, we noted that the lighting in the back stairway, among many other things, was out. And after months and months of having the lawn care company out assess it, we received notice, which we included with our email to the plaintiff's law firm, that they refused to repair it. And my mother-in-law slipped and fell down the back stairs and broke her foot. And that's all documented. She was over at St. David's Urgent Care B Cave shortly thereafter. And so so that is.
Did a lawyer draft up a potential lawsuit?
Yes, my father.
Your father is a lawyer?
Yes, he is. He practices in Houston.
Then Mr. Slade, I'm going to deny your motion to continue. All right, Mr. Olds, what's this case about?
Your case, simply put, is about Mr. Slade's failure to pay rent.
Non-payment.
And he's And my client, so I have my client on the stand if the court wants to hear her actual testimony, but
Y'all, it's a non-payment matter. Give me the set of facts, and if there's a dispute, then I'll take the witnesses. But it's non-payment. It's not non-payment rent.
absolutely. So there's a lease entered into between my clients and Mr. Slay. That lease ran from October 21st, 2024, with an expiration date of April 20th, 2025. On about April 9th, 2025, my clients provided the tenants the written notice of lease termination pursuant to the lease agreement, which requires a 30-day notice of lease termination. Sent that notice. Tenants did not vacate by May 20th, 2025, and have continued to occupy as holdover tenants since that date. Pursuant to the lease, rent is actually 3 times the normal. So the rent amount was $15,000 per month during the time of the lease. Since they're holdover tenants, it's actually now $45,000. That's beside the point because it hasn't paid that amount.
What? Did he just say fucking $15,000 a month? And because they're holdover clients, they gotta be $45,000. Is that what he just said?
2025, and have continued to occupy as holdover tenants since that date. Pursuant to the lease, rent is actually 3 times the normal. So the rent amount was $15,000 per month during the time of the lease. Since they're holdover tenants, it's actually now $45,000. That's beside the point because it hasn't paid that amount. Beginning on or about May 20th, though, tenants did make some rent payments to my clients in the amount of $15,000 on the 20th day of the month through July 20th. But since July 20th, have not paid any rent money to my clients. They paid no money.
Okay.
September.
Mr. Olds, y'all sent a letter, a notice to vacate in April, and that was based on a non-payment.
The
What was
April
notice to vacate notice
that,
about?
that was a notice of vacate. That was the lease termination letter saying we're ending the lease. We're not going to continue this lease. Please get out when the lease ends.
When did you give them a notice to vacate for the lease violation?
For the lease violation, that was September 8th, 2025. They're given a 3-day notice to vacate.
3 days, September 8th. And then that 3-day notice, what's the reason that the notice was given? What's the violation?
Sure. The letter says, would you want me to share my screen, Your Honor?
No, just, right, what does it say?
Sure. It was basically, despite the landlord's April 9th letter, you did not vacate the property by May 20th, 2025. You occupied the property as holdover tenants, pursuant to the lease.
So the 2 notices are because you're a holdover and you haven't made payment. I'm looking at the
Yes.
letter, September 8th, the U.S. mail and certified mail, 3-day notice to vacate pursuant to Texas Property Code. This letter is written on behalf of the landlord. As you're aware, you have a residential lease. The lease expired April 20th. By a letter dated April 9th, we notified you that your tenancy was going to terminate the following month. You must vacate. Despite getting that letter, you did not vacate. So 1, you're a holdover. And 2, you haven't paid the rent as required as a holdover. So when he became a holdover, the rent tripled to $45,000.
That's correct.
Did he attempt to pay the $15,000?
He paid the $15,000 through July, but has not paid anything since July.
Your Honor,
No payment
by and
since-
through,
So he paid July, Mr. Olds?
Well, he paid $15,000 through July 20th of this
And
year.
so rent had been being paid on the 1st of the month. Is that what the lease required?
I believe that's correct. My client can confirm that, but I believe that's correct.
So a dispute arose in April about whether or not he was a holdover. And even if there's a holdover, there's a dispute about whether it's $15,000 to $45,000. Was there a point at which he paid nothing toward the rent?
Yes, beginning the last payment he has made was July 20th. He has not paid any rent since then.
All right. And has a copy of the lease been provided?
Yes, Your Honor. That is, I believe.
Does the lease have the terms of the holdover and the renewal rates?
It does.
Oh, do you recognize this as a copy of the lease from your client?
Yeah, that looks correct, Your Honor.
Mr. Slay, is this like a copy of the lease you signed?
that is the original one through April 20th. We signed an extension through October 20th, which council has failed to mentioned.
Mr. Slade, we're gonna get there. I want to see y'all's lease, right?
Sure.
This lease says it's October 21st to April of 2025. This is the lease the parties entered into. Mr. Oles, were there any additional leases signed besides this one?
I'm not aware of any additional leases, Your Honor, no.
Mr. Slade, just yes or no? Did you sign any additional leases?
Yes.
Okay. Automatic renewal happens to everyone, goes month to month unless you get 30 days. So it ended April 20th. And when did y'all said April 9th you gave in
Okay, I just looked it up. The house is got a Zillow estimate of $2.6 million. 5 bedrooms, 7 bathrooms, 5,650 square feet. Look at the backyard and the pool. Wow. 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 What a property. Would you rent a property? If you can afford to live here and pay $15,000 a month, why wouldn't you just buy it? Wow, wow, wow. Pretty nice. That's 2.6 American dollars in Austin, Texas. Oh, look at that backyard. Look at that. That looks like a tennis court and a basketball court. It's a full-size basketball court with a volleyball net up. A pool. Some employers will pay your rent but not your mortgage. There you go. I guess. I fucking guess. Well, I would live there.
a notice of non-renewal?
That's correct, Your Honor.
Told them to be out by end of May.
I believe it was May 20th. Yeah, May 20th.
So you needed to tell them by March 20th. Otherwise, it automatically renewed. Y'all
5 days before my birthday.
April 9th. So it had automatically renewed per the lease. Because you had to give, the landlord said we must notify 30 days, either one of us. And if we don't, it automatically renews. And since the landlord
Right, so
missed the
we
30-day
gave more
deadline,
we gave more than 30.
Mr. Olds, automatic renewal. This lease automatically renews
Correct.
unless the
Oh,
landlord
I see. Yes.
gives notice 30 days before the expiration. So it expired April 20th. So the notice needed to be sent by either one of them March 20th. Your client was late. So it already renewed by the time they sent that non-renewal.
Yes, but the 30-day notice was more than 30 days before they were told to leave.
Mr. Holmes, you just told me that y'all said your client sent a non-renewal notice April 9th. Is that correct?
It was a written notice of lease termination.
We're saying the same thing, non-renewal and termination. They sent that notice April 9th.
Yes.
So that is not 30 days before the end of the lease as required. So it already renewed.
Yes, I understand what Your Honor is saying, but
I'm reading the lease.
yes, but they're
Right?
even more than
If this
30
was
days.
reversed, if this was reversed and the tenant had sent that notice on April 9th, your client would have been 100% correct to say, no, you've already become a holdover for a month. We've already automatically renewed. You're not a holdover, you have a whole 30 days. If you're willing to terminate with me now, you owe me rent through the end of May and then you can terminate.
Sure, so renew on a month-to-month basis.
It removes on a month-to-month unless landlord or tenant gives the other party notice not less than 30 days before the expiration. So it expired April 20th. One of the two parties needed to tell the other, we're not going forward with this relationship, and that had to take place by March 20th. Defendant didn't say anything. Landlord didn't say anything. And then 11 days before this lease came to an end, your client sent a letter that said, we don't want to renew. Please be out May 20th, which was an incorrect notice because they already had until April. They already had until May 20th per the automatic renewal.
Yeah.
Right? Okay. So
But legally had to get out by May 20th. Legally had to get out by May 20th. Yes.
So they gave written
I'm
notice.
not disputing they had to get out before May 20th. I think that's right. Yeah.
All right, so they said we don't wish to renew. And at this point, when the non-notice was sent, April 9th, tenant was current in the rent?
Yes.
Okay. And then May rolls around. Tenant pays the May?
It did pay the May.
And how much did he pay in May?
I believe it was the $15,000.
And did your client say, send him a letter that says, hey, you're short, you should be paying us 3 times that amount?
I don't believe it did for May, no.
Okay, how about in June? Did the defendant pay in June?
They paid June and July $15,000 through July 20th.
Rent was due the 20th.
In August?
I'm sorry?
So in August, no payment was made at all?
No.
All right. So then we get to the September notice of vacate. As you're aware, you previously entered into the lease. That's true. The lease's primary term ended April 20th.
No, I'm not fixing a knot off. I am tired though. Yes, I am.
I would tell just, I'm looking at the notice of vacate, and I would say that I would disagree with the first assertion in this one, right? So I don't deem him as a holdover at first, because the landlord gave a notice to not renew, but they were late in doing it, so he got an extra amount of time, right? But after that, landlord said, I don't want you anymore. Then it did become what would have been a holdover, except that, well, the fact that you pay doesn't change that situation. So he is a holdover at some point. It's just not as soon as you asserted it as it's put here, right? But it gets there because the notice that was sent, even if you pushed it out, only got him through the end of, at best, June. So in July, there's a holdover situation. In August, definitely a holdover situation. And so the September 8th letter is misstating of the dates, but is not incorrect in that a holdover exists. All right, but let's look at the non-payment because that's also a situation. Now, payment wanted to be 3 times the rent. So by the time we get to August, let's go back to the lease. Mr. Rolls, where in the lease can I find the renewal rate or the holdover rate that triples it?
It's paragraph 22.
Okay, holdover.
Hey, Brutal Bob.
Yep, pretty standard. Rent for any holdover period will be 3 times the monthly rent calculated on a daily basis and immediately due and payable without any notice or demand. They don't have to advise you about it. They don't have to say, hey, don't forget. It's just part of the lease. There it goes. All right. And then nothing got paid in August. Nothing's been paid for September. Nothing for October.
That's correct, Ron.
Well, rent is due the 20th of the month.
All right.
So rent is not due. We were, once again, we signed a lease extension through October 20th.
Oh, Mr. Slade. Mr. Slade, do you have a copy of the lease extension? Because I'd love to see it.
Yeah, let me see here.
Did you submit it to
Lease extension. They just said they didn't sign a lease extension.
No, I haven't had a chance to submit anything. I'd honestly, I've been emailing with their attorneys, not only Mr. Rolls directly.
Oh, you said you hadn't talked to an attorney, Mr. Slade.
No, I haven't. I was emailing with their attorneys. The gentleman here. No, my father's an attorney. That's really it.
Mr. Slade, can you pull it up so we can let you screen share?
Yes, I'm trying to find it here. Here it is. Okay, how do I screen share?
We're going to make a limited share. Mr. Slade, I'm going to give you a warning, and I give this to everyone. When you screen share on Zoom, if you're not familiar, it will literally share the whole screen. So if you have extra tabs open or instant messages that pop in, maybe minimize all of those things so that when you choose to share your screen, it's going to show all open things on your desktop. Just FYI. I've also learned a lot about Zoom in the last 6 years.
And then, Your Honor, you're the host.
Oh.
Okay.
All right, there you go, Mr. Slay. Giving that back to you, Brochet.
Okay. And so now
Yes,
you'll just
this
have to
is
submit.
live. I'm live.
And I would add, this was negotiated between our real estate agent and their real estate agent, and we have the text messages that say that they would agree to this. And yet they, we found out really, April and I signed this back in May, or whenever this was executed. And then
So you
they
haven't
never
shared
sent
your
us.
screen yet.
Oh, I clicked the button.
Share it.
Try
Share
again.
your screen.
Okay.
Mikey, this guy's
There
paying
we go.
$15K a month in rent. Oh my God, sir. She just
Alright, so
told
that's
you not
really
to show us
only
these
renewal.
videos.
No, this is the renewal.
All right, yeah, there we go. All right, so this one is May 21st, 2025 to October of 2025, so a short extension. Mr. Slay, who is the DS initials to the left on number 4?
Those are mine.
And who is the AS below that?
That is my white paper.
Where did you get this document from?
This was sent to by their real estate agent to our real estate agent to us, signed via DocuSign.
Mr. Olds, can you confirm with your client if that is correct?
I have not seen this before, Your Honor. I'm not sure my client has signed it. I don't see anywhere that they have
That's
signed
not what I asked. Did they send it?
I'm not aware. My client's on the call.
Would you like to take a minute and ask him? This isn't a very specific kind of document here that directly contradicts the things that you told me. So
Angie,
if you
could
want
you
to
please get on
for
it?
your client, we can, but like if they prepared and sent this to the defendant, that's an offer to renew, and if they sign it, they're stuck with it.
Sure. If I could
Really any holdover
talk
order.
to my client really quickly.
Why don't we take a short recess and we'll give you a chance to go into a private breakout room. All right, Mr. Slade,
Okay.
screen sharing.
Stop screen sharing.
Oh my God, did
Yeah,
you hear
stop
that?
screening.
So here's the deal. They wanted, they have a lease for $15,000 a month. The house is worth $2.6 million in Austin, Texas. And these folks have been paying their rent, $15K a month. The lawyer just purported that they had been holdover tenants, which means they didn't sign a new lease and they've stayed there against the wishes of the owners, and therefore their rent goes from $15K to $45K. Now, the lawyer doesn't really seem that informed on what's going on here. Mr. Slay, on the other hand, is sort of slaying. Let's see what happens. She's going to send them to a breakout room. We're going to skip ahead, and we're going to see what the deal is. By the way, Adam, a $2.6 million house where I live is a shithole. Don't have a pool. It don't have none of that.
What we'll do is we'll give it a recall. Mr. Olds, if you need a moment, we can give you a breakout room. Otherwise, you can put yourself on mute and contact your client. Mr. Slade, please don't go anywhere. You can also put yourself back on mute. We're going to go to the next case and we're going to recall this one, okay? All right. Thank you. Mr. Villarreal there for 2530 law, but I say I
Correct,
appreciate what you're doing for your tenant there, despite and kind of the situation. All right, then today's going to be
Here
a
we
judgment for the
go.
plaintiff. It's a possession only
By the way,
award.
this is our
I
last
am
bit of a
reporting
case,
that
and
based
then
on both
we're saying
non-payment and
goodnight.
lease violations. And then if either party wants to appeal, I would use the red amount of 1845 on appeal. But Mr. Lutton, if you or him wanted to appeal, and he can't afford it, they would qualify for an affidavit. Okay, sir?
All right, so it's 5 calendar days that I can file for them.
That's right. On day 6, you can seek the writ of possession with us.
All right, well, thank you.
All right, good luck, sir. And you have up to 60 days to do that. So let's say you're working with Mr. Villarreal and you want to give him, you have up to 60 days to seek that writ of possession.
Okay,
All
thank
right.
you.
Thank you. All parties are excused. Have a good morning, sir.
You too, bye-bye.
All right, now, Mr. Olds, I see we've returned, so would we like to recall that matter?
Yes, Your
Come
Honor.
back now to cause 251337. All right, just real quick, when we left, we were taking a look at a renewal that Mr. Sly said he had received from the plaintiffs. All right, Mr. Old, what did you discover?
Yeah, so what happened was there was an offer to extend through October that a colleague in my law firm sent to Mr. Slay, and then he unilaterally made changes to that document that we did not agree to, and then he signed it, and we.
Thank you, Carla, Toonie, and the Cookie Fund. The cookies turned out great, by the way. And thank you so much for the Toonie. I love that. Daniel? You fucking shit up. And I'm getting the vibes that just like every Daniel in my life, no offense if you're a Daniel in my life, you're fucking shit up.
Never countersigned.
I have text messages. Sorry.
Mr. Olds, what changes to the offer did the defendant make?
I'm not sure. I don't have a copy of it in front of me.
Who rejected it? Who said that, hey, he made changes?
I didn't reject it, baby. I took Bill's Toonie.
I spoke with my colleague, and he is supposed to be sending me a copy of it, and he has not sent it to me yet. But he told me
Thank you,
that's what
Bill.
happened. So apparently he scratched it out on the document. So if you could pull up that document again, I think there were some changes that he made to it before he signed it.
Mr. Slade, do you know if you made any changes or alterations?
Yeah. Can I share my screen again?
Yeah.
The only change was that we noted that they would not be able to show the house while we were still living in it.
Cool. You made a change. All right. So
and there's the agreement. There's the agreement where they agreed to.
So I just got an email, Your Honor, from my colleague. So sections 14D1 and 2 are what was struck through.
All right. So Mr. Slade, you wanted to make changes, and you said, hey, I've sent it over. And then did they sign it and send it back to you with those changes?
They agreed to. This is the only contact we have with them. This is their realtor. She works for Kamara Wilcoxon, I guess their head realtor, who indicated that they would they agreed to it to just initial and do the strike throughs. And this was a screenshot sent from our realtor.
Do you have any idea what your client, who Jessica Doskar is? Because she says, hi, David, the owner has agreed to proceed with not showing at the end of the lease. And I can see that it's dated June 16th. But this would appear to be an acceptance of his alterations or his amendment.
Well, my client does work with Kamara Wilcoxon, but so this person works with her. I suppose that's true. I don't
see how they're not in a new lease.
I don't think that this is an acceptance of the changes that he made, though.
Hi, David. The owner has agreed. Please send the lease docs with the initials. I don't see any way to not approve that as an acceptance of the offer.
So he struck through.
Hi, David. The owner has agreed to proceed. Please resend.
I don't think it was ever signed. I don't think it was.
Mr. Olds, it's striking me that maybe the story is not as clear from your client's side, but right now what I've got is, after I was told there was nothing, it turns out they did send from your firm an offer to renew. Defendant made changes, and those changes were accepted right here by someone who appears to have agents in the ownership. So I'm not sure why we're here, because they're not a holdover now. We're going to get back into non-payment. So the non-payment is going to go back to the $15,000 amount. Mr. Slade, did you offer the tender payment at $15,000?
I've been doing that until we were notified, and here I can share this screen too. Does this automatically share? Do I have to stop share and reshare?
You have to stop sharing.
Okay, and then I'll reshare. Again, we noted when we moved in that the backlighting didn't work.
Yeah,
I'm
not worried about that. This is a real simple situation, right? All the other things, because it can't have been too bad. Y'all negotiated to stay longer. And here it seems like they approved it. So these are more text messages. I don't care about lighting. Here's what I got. Here's Mr. Olds, Mr. Slade, here's the situation as I've heard it so far. The plaintiffs leased a home to the defendants. The lease came to an end. The defendants did not receive timely non-renewal. In fact, the plaintiff was late in giving them a notice of non-renewal. Even after the late notice of non-renewal, the parties then decided to negotiate, and they did. Plaintiff sent over a new lease, which defendant amended, and said, I don't like your offer, I want a counter. And then plaintiff accepted the counter offer, which I take to be true through that text message just shown. That means that once defendant sent it back, they have a new lease. So it's not possible for them to be a holdover. So then we get into whether they paid the rent. I didn't see anything in the renewal that changed the amount of the rent, which means it was at $15,000. Mr. Slade was trying to tender $15,000 correctly, and plaintiff is saying, no, you need to give me 45. I would say plaintiff is incorrect.
He hasn't paid anything. He hasn't even paid 15,000.
So, Mr. Slade, you haven't paid since July, correct?
Rent was due July 20th. I did not remit payment on August 20th or September 20th. I was trying to negotiate with plaintiff. I had actually initiated payment, I guess the day that, within 30 minutes after this was filed, and I sent plaintiff.
You can't pay late. Here's my point, Mr. Slade. Per the terms of the negotiation that you renegotiated, rent was due on the 20th, right?
Yes,
Okay, and did you pay on August 20th?
I did not.
Did you attempt to pay on August 20th?
I think, no.
Okay,
On that
about
date.
September 20th.
Well, September 20th, they filed this notice before
Yes,
then.
but you're still
this
in
eviction
possession. The fact that they're trying to evict you doesn't mean you don't owe them rent.
notice. Actually, I know, I actually initiated payment for all 30,000 on the 19th. I ceased that payment when this eviction proceeding began, because I was told that I had now owed 45, and so I actually forwarded to their office the ACH confirmation from Frost Bank for the 30,000.
Okay.
And, I would happily redo that immediately, but here we are. We paid over $165,750 in rent over this year. This comes to you because we wanted to buy the house, but and we had verbal agreement similar to these text messages that we've shown you that they would let us buy the house, and then that was reneged. And so, we had a daughter. Our daughter arrived on May 16th, and they knew that. They sent us a notice to vacate on May 20th. It's all like harassment a lot of this time.
Your Honor, may I say something, please? Would that be possible? This is Angela Roberts.
Mr. Roberts, I'm going to ask Mr. Old to delay you in a line of questioning because he's your counsel and you're not prohibited from it. Mr. Old, do you want to ask questions or? Mr. Roberts, you can. You have an attorney here, and typically the attorney wants to be kind of gatekeeper for that. So I'm just making sure.
If Mr. Roberts wants to say something, I'm fine with that.
Go for it then, Mr. Roberts. Yes.
So, just the summary of events is that we've been very good to them, and they've been dishonest with us about the ability to finance, and even sent an email saying that they were trying to get a line of credit with Frost to be able to pay, and then basically sent a blackmail email to the attorneys, which I have never seen anybody say, if you don't allow us to stay and work with us, we're going to sue you, have our mother-in-law sue you. That email was sent to my attorneys to tell me, and I've never been treated that way, and we've been very good to them and have been very understanding through a lot of this. And I just want it to be over because we've bent over backwards. We even accepted them when their credit score was low, and we've been nothing but decent human beings, and I don't think we've gotten that in return, and that's all I wanted to say.
All right, Ms. Roberts, thank you. Mr. Olds, Mr. Slade, Mr. Roberts, thank you all today. As I look back at the paperwork, I find that the answer lies in the notice of to vacate. I'm going to share my screen, okay? So
Judge
this
is
is
about
the
to
notice
lay
of
down
vacate,
the
which
law.
starts the process for an eviction suit like this. It is a necessary
have a
required letter.
Discord.
It
I
must
bet
provide a
Cellular
settlement with
Overpass is
another
going to
tenant.
post a link
The
momentarily.
notice must give it must be correct in the notice that it gives, right? When I read this notice, I find it to be factually incorrect. I'm going to explain why. One of the first things you say is that the term has expired. I don't find that that's true. I find that's not true for two reasons. One, per the terms of the original lease, the landlord and the tenant both had a duty to notify at least 30 days in advance. The landlord did not do that. Since the tenant did also not say anything, it automatically renewed for another month. So it's not possible for that original that holdover to be true right? Even beyond that, parties then negotiated in good faith for an extension of the renewal. Now, maybe that's because y'all were trying to buy the house, and deep down, all parties thought y'all were going to make good money at the end of this. Someone's going to get a house, and the landlord's going to walk away with big money, right? But I can see that the landlord sent over a new lease, a very new lease, clearly through October. And then the tenant modified that and sent it back and said, we'll accept it with these changes. and an agent for the plaintiff said, "We accept." And it's not necessary for the plaintiff to sign the lease because they sent it and they agreed and they received it back. They're getting the benefit of that, right? So with that renewal, unless you change the rent was still $15,000. So when this says that you're behind because you owe treble times, that's an incorrect statement of fact as well. For those two reasons, this notice is ineffective, and today's going to be a judgment for the defendant. Mr. Coles, the client can absolutely appeal my decision. For this type of case, I would also set the appeal bond equal to 1 month of rent, so it would be $15,000. Certainly, I recognize that's a substantial amount of money. So if the client can afford that, which might very well be a thing that you don't have that much cash readily available, they may qualify for the affidavit of inability, and that would not, but the fact that you have a lawyer doesn't necessarily change some of that situation. So you both have 5 days to appeal. You can also do other things with it. All right, so that's it. All parties are excused. Thank you.
Thank you.
Oh my god. Also, I thought of something. They just fucked up. They got themselves into this exact same problem. Do you know how? Because that new lease expired October 20th. It's October 7th. They're too late. They didn't send the notice. It automatically goes. Oh my god. Oh my god. They're not going to be holdover tenants again. Wow. That was quite the case. Very unusual for a landlord to lose in a landlord-tenant case like that. Extremely unusual to have a lawyer lose against a pro se litigant. But that's what happened. That's what happened. Reminder, I'll be back at it again tomorrow. Probably just one show tomorrow. I'm not sure. Wait, is it Monday? No, it's Tuesday. Monday was exactly yesterday. So I will be back tomorrow. Keep an eye out. I don't know what time yet. I'm sorry. I can't tell you what time. But I thank you for your patience. I know all of you have much more than I do. I am an impatient girl, and that's the way, I like it. Seriously, do me a favor. Remember that I love you. And I'm proud of you. Oh, that's awesome, Carla. Make some fudge. Fudge. I love you guys. I'm proud of you. And I'll see you in the next video. Bye. I said bye.
Way down and ready to ride.